6 police officers approach a second-story apartment with their handguns drawn, pointing at the front door and the window. They shout, "Open the door." When an innocent woman opens the door, they lower their handguns but still don't holster them. They ask this woman whether an individual by the last name of Martin lives in this apartment building. When she says yes, they tell her that she needs to get out and they need permission to enter the apartment. What is their excuse for not getting a warrant? Knock and talk exception. So today we're going to discuss the knock and talk exception and whether consent that follows the knock and talk could be valid. Before we go on, I want to thank you for watching me here on YouTube. If you're new to the channel, every Wednesday we go into a deep dive on one criminal case. Today it's one from the Ninth Circuit. We usually discuss the Ninth Circuit and the Supreme Court cases. And every Friday I give you sort of an overview of some of the news that happened in the days prior. Today's Wednesday, we're going to this deep dive. Thanks again for watching me on YouTube. Hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks a lot for watching.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStache YouTube page. That's LAWSTACHE.
Today we'll be discussing a Ninth Circuit case, United States versus Dwayne Martin. Now let's begin with some basics. The Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct any search or seizure. Now your home gets the most protection. As you notice in the text of the Fourth Amendment, your home is specifically enumerated in the text. Now the area that surrounds the home, called the curtilage, also gets protection. It is the area that's intimately connected to your home, like your front yard or the driveway. Now, throughout the years, the Supreme Court has established a number of exceptions to the warrant requirement of the Fourth Amendment. Some of the major exceptions here in this case are consent and knock and talk. So let's begin with the knock and talk exception, which allows the officers to approach the front door and knock on the door and engage with the occupants. The knock and talk exception permits police to encroach upon the curtilage of a home for the purpose of asking questions of the occupants. The exception is based on the theory of implied consent. A resident's consent is implied from the custom of treating the knocker on the front door as an invitation, that is a license, to approach the home and knock. The constitutionality of such entries hinges on whether the officer's actions are consistent with an attempt to initiate consensual contact with the occupants. Now, I already mentioned some of the facts from the case in the beginning of this video. So what do you think? Does the conduct of the police match the knock and talk exception? Well, let's find out. I will read to you straight from the case. The officer's actions here are not consistent with a knock and talk. The body cam footage showed that 6 officers approached the Cormacks apartment and positioned themselves around the front entrance of the apartment. 3 of the officers with their guns drawn and pointed at the front window and door. One of the officers positioned by the door knocked as the second officer yelled, "Open the door." The officer in the front of the door kept his gun pointed at the door until the door opened and he saw Miss Cormack. The officer then lowered his gun but did not put it in the holster. An officer asked if Martin was in the apartment. When Miss Cormack answered that he was, another officer told her, "We're going to need you to come out." Now, if you remember a case, United States versus Chan-Jiminez, it is one that I have previously mentioned and discussed on this channel in detail. That case from the Ninth Circuit noted that consent was not voluntary when the officer's request for permission to search was made with one hand resting on the officer's gun. Also, in the United States versus Marshall, another Ninth Circuit case, the court concluded that any consent to a search was in response to an overwhelming display of authority under the compulsive of the badge and the gun and not voluntary. So the court says, given the situation, the amount of officers, the fact that they're pointing a gun at Miss Cormack, an innocent individual, this does not sound like a knock and talk exception. Knock and talk usually applies when the officers are trying to make a consensual conversation. The idea is that we're using the custom of this country that an individual can come up to the front door and try to engage with occupants. Nobody ever comes up to your front door with a handgun drawn and pointing at you. So the court says the knock and talk exception does not apply in this case. So the next question becomes, does consent save the day? The fact that Ms. Cormack consented and allowed the officers to enter her apartment. Now, before we go on, I want to remind you, consent is one of the major exceptions that we see over and over and over again in criminal cases. But never consent to searches. You don't have to consent. But that is the easiest way for the government to prove that none of the exceptions are needed, because consent usually saves the day. As long as it's voluntary and there's no pressure, the individual consenting gives up and waives all of their Fourth Amendment rights. So again, never consent to governmental searches and seizures. So let's go on and talk about consent. The illegal search occasioned by the knock and talk is not saved by the consent exception. The government bears the burden of proving voluntary consent, and we consider 5 factors and the totality of circumstances in evaluating voluntariness. The government argues that the officers tried to de-escalate the situation once Ms. Cormack opened the door, and so the consent was voluntary. But the court disagrees. The court says that even though the officers put their guns down, they still did not holster them. And now remember, we're on the second-story apartment, which means that there's only one entryway into the apartment. Ms. Cormack would not be able to leave, and she would not be able to go back into the apartment. She was stuck in the doorway with 6 officers. Now, she was not in custody, but this still shows some apprehension on her behalf to close the door. Moreover, when one of the officers asked for permission to enter the apartment, he did, with the consent, but so did 2 other officers. In total, 3 officers made the entry. And if we're talking about consent, the court also noted that Ms. Cormack audibly told the officers how upset she was at how they conducted themselves and the manner in which they approached the apartment, which again shows that there was no consent. So at the end of the day, the court says that consent does not save the day. This was in fact an illegal search and seizure. Now, if you've been paying attention to my videos, you usually hear me talk about the poisonous tree doctrine and the fact that information and items that are seized usually get suppressed, which means they cannot be used against the defendant in trial. So you might be asking yourself, in this case, what are we trying to suppress? What did the officers find inside the apartment? Well, the interesting thing about this case is that Mr. Martin was arguing that the suppression has to be the information, the fact that the officers now know that he lives in this particular apartment. Why is that important? Well, because with this information, they created a nexus between Martin and the apartment. And they put that information in the probable cause statement, in the affidavit, and they requested later a warrant to search the apartment, in which they found a handgun. Now, of course, the handgun came as a result of a warrant. So Mr. Martin argues that that warrant was not valid because it was based on an illegal search and seizure, and they would have never found out the information without the knock and talk and essentially scaring Miss Cormack into revealing that he lived in that particular apartment. So that is the information that was being suppressed. I hope you've learned something about this particular exception, the knock and talk, and how the consent does not save the day in this case. If you like this video, please give it a thumbs up. Please subscribe to my channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of my merch, including the Do Not Arrest This Person t-shirts, hats, and other items. And this month, I now have a new sticker, which I'll be throwing into all the packages when I mail you the t-shirts. Thanks for watching.